Hi, bankruptcy attorney Brian Barboza here, and today I'm going to discuss whether or not a bankruptcy will in fact stop a wage garnishment. Before we get started, if bankruptcy is something that you are interested in exploring or want to talk more about, please feel free to give me a call. Go to my website, barbozalaw.com, and book an appointment to speak with me for free directly through my website. Okay, so will a bankruptcy or filing a bankruptcy stop a wage garnishment from either starting or continuing? The short answer is yes, but the real question is, will it stop the wage garnishment temporarily or permanently? And what I mean by that is this. There are two factors to this. Number one, the day you file bankruptcy, what happens by operation of law is what's called the automatic stay goes into effect. This automatic stay is an injunction, and it stops your creditors from trying to collect money from you while you're in bankruptcy. So if there was a wage garnishment order, if we had, let's say my office filed the bankruptcy case, we would contact the plaintiff's counsel that represented the creditor in the lawsuit, and we'd also contact the sheriff's department because they're usually in charge of enforcing judgments, and make sure they're aware that the bankruptcy has been filed, and they all know that once that happens, the wage garnishment would have to stop. Okay, now, if during the pendency of the bankruptcy, that wage garnishment would stop. However, if the debt is the type of debt that you could get rid of in a bankruptcy case, so it's what we call dischargeable debt. Let's say it's a credit card, was originally credit card debt, or a personal loan, or a former auto repossession, or a old medical debt, something like that. And the bankruptcy concludes successfully, and that debt is discharged, then that creditor would not be allowed to resume the wage garnishment. So in that instance, the wage garnishment would stop permanently. Okay. However, if the wages were being garnished because of a debt that was not dischargeable in a bankruptcy case, let's say it was for child support, spousal support, generally student loans are not dischargeable in a bankruptcy case, or recent tax debt, let's say the IRS was garnishing your wages, when the bankruptcy was over and that debt was not discharged in your bankruptcy case, then those creditors would be allowed to then resume the wage garnishment order and start again garnishing wages. So it really depends on the nature of the debt and whether or not it was discharged in the bankruptcy case. But either way, during the pendency of the bankruptcy, wage garnishments would stop. If you did have one of those debts, by the way, that was not dischargeable in, let's say, a Chapter 7 bankruptcy case, then you would probably want to consider maybe a different chapter of bankruptcy, like a Chapter 13, which is more of a structured repayment plan over 3 to 5 years. And during the pendency of those 3 to 5 years, while you're making your plan payments, generally those wages would not be garnished. Okay, so there are some other alternatives within the bankruptcy world that you could explore. That's it. I hope you got something out of that, shorty but a goodie, but I thought it was important because I've had a lot of people lately come to me with wage garnishment orders and issues, so I thought that would be helpful. As always, if bankruptcy is something that you want to talk more about, you're interested in exploring, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment to speak with me for free directly through my website. All right. Well, I hope you got something out of this video. Hope you enjoyed it, and thank you for watching it, and have a good rest of your day. Bye.